case, please.
Darrell, Tipton et al. Versus William J. Wolfenbarger et al.
Good morning. May it please the court. My name is Michelle Alsop from the Chattanooga Bar. I'm here on behalf of the appellants, William H. Worley, Rebecca Worley, and Bill Worley Construction Company. I'd like to reserve 4 minutes for rebuttal.
4 minutes, that'll be fine.
Thank you. Unless the court would like a brief recitation of the facts of this case, I'm happy to delve into the 2 issues before the court today. The first issue is whether the trial court erred in awarding Darrell Tipton a percentage interest in the sales proceeds where Mr. Tipton did not appear at the evidentiary hearing and there was no evidence warranting a distribution of the portion of the sales proceeds to Mr. Tipton. And the second issue, whether the trial court erred in awarding Darrell Tipton a percentage interest in the sales proceeds, where the trial court based its holding upon certain erroneous deeds and improper deposition testimony rather than the evidence presented by the Worley appellants. Beginning with the first issue, the trial court held an evidentiary hearing on May 31st, 2022. The issue to be determined at the evidentiary hearing concerned the allocation of percentage interests in the sales proceeds from a partition by sale of a certain parcel of real property in Madisonville, Tennessee. It is noteworthy that the Worley appellants were the parties that moved the court for this determination. At the evidentiary hearing, the only parties to make an appearance were the Worley appellants, William J. Wolfenbarger, and the intervening petitioner, Hydro Sports Custom Boats, LLC. More importantly, the only parties with an actionable interest in the sales proceeds that appeared were the Worley appellants and Mr. Wolfenbarger. Darrell Tipton did not appear at the evidentiary hearing. As stated in our brief, Mr. Tipton's failure to appear constitutes a waiver of his alleged interest in the sales proceeds. Specifically, we submit that Mr. Tipton has failed to prosecute his claims, thereby establishing the waiver. Under Tennessee law, waiver is a voluntary relinquishment of a known right, and the voluntary element can either be a direct action or inaction of a party, an example of an indirect action being just this. At the evidentiary hearing, the trial court took note of Mr. Tipton's failure to appear and the fact that the failure to appear would have its consequences. Specifically, the trial court stated, quote, "They fail to appear at their own peril. They knew and they were properly noticed. If you fail to appear, that doesn't make this case any less ripe to try," end quote. The record reflects that Mr. Tipton filed the original complaint for partition, and the record further shows that other than filing the complaint and a motion or a response to a motion to intervene, Mr. Tipton did not move this litigation along, which the trial court also noted at the evidentiary hearing.
I'm going to interrupt you here for a second. Assuming all that's true and he didn't show up and he didn't participate, if there was nonetheless evidence presented which would show that he was entitled to his 1/3 interest, you can't negate the fact that's there and is in the evidence just by virtue of the fact that that particular person didn't show up.
Well, I will get to that, specifically the fact that it is our position that the evidence was not competent because a party without standing put on this evidence at trial. That party being Hydro Sports, the intervening petitioner, whose interests had been satisfied by both the sale and the placement of the $850,000, the sales price, into the registry of the court. The court also took note of this at the evidentiary hearing, that Hydro Sports did lack standing to participate in the issue of the allocation of their percentage interest of the proceeds. So therefore, it's our position that this plaintiff did not appear. Also, the proof that was before the court was not competent. The evidence was not put on by the plaintiff. It was put on by an intervening petitioner whose interests had been satisfied.
I'm not sure you answered Judge Davis's question. If and I understand you say your position, the proof is not sufficient, but if there is proof there that Tipton had an interest in the property, is it your first position on this that by not participating in that interest is just gone?
That's not necessarily our contention. Our contention is that the proof that the Worley appellants put on is the competent proof. There are issues in the chain of title concerning Mr. Tipton's interests. The Worley appellants placed into evidence a receiver's report from a related case concerning Mr. Stooksbury versus various judgment debtors, in which the receiver's report demonstrated that the percentage interest was divided between three parties, none of which were Mr. Tipton. In fact, the receiver noted that Mr. Wolfenbarger, who was a party to this action, the receiver and Mr. Wolfenbarger were attempting to effect a sale of this particular property, the sale of which did not involve Mr. Tipton. Furthermore, there was evidence presented by the Worley appellants from Mr. Wolfenbarger that Mr. Tipton did not retain an interest in the sales proceeds anymore, as his interests had been bought out previously. So we're saying that the proof that was put on that was competent proof was also the correct proof.
Let me ask you this. All of this stems from the original deed of trust that listed Mr. Tipton and then the two Rosses as the purchasers of this particular property. All of your argument really sort of hinges upon this idea that each of them did not own a third. Because if they each owned a third, then, and it's undisputed Mr. Tipton didn't do anything with his third. The other two people, there were lots of things going on with their, what they did with their portion of the property. But Mr. Tipton never deeded or promised or pledged or did anything to his third, correct?
I would dispute that in saying that we are unsure of that. I mean, the receiver's report reflects that he is not.
Well, that's the only thing that does, though, right, is this receiver's report. There's no one's testified or come up with a deed or anything that Mr. Tipton signed saying, I'm transferring my 1/3 interest to somebody else.
That's correct. There has been no deed.
Okay. And if that's true, and we say that he's owned 1/3 from the start, then he's owned 1/3 from the start.
But it is also his burden to demonstrate that. It wasn't Hydrosport's burden, it was Mr. Tipton's burden. Even the partition by sale statute and the case law related to that, which we don't necessarily cite in our brief, but it does demonstrate the case law that the partition, that party that brings that action has a heavy burden to demonstrate an interest in the property, and we would equate that to the sales proceeds as well. He had that burden on the day of the evidentiary hearing and was not present for that.
Would the deed itself not meet that burden?
If the court took judicial notice of the deeds, which that was also not offered to the court. The court, neither Hydrosports nor the Worleys asked the court to take judicial notice of these deeds.
So the deeds are not in the record?
They are part of the deposition testimony. They were not individually admitted as exhibits to the hearing. They are exhibits to the deposition testimony, which again, we submit the depositions themselves were erroneously taken. One, they were taken by a party that had no standing to take them. Again, Hydrosport's interests had been extinguished at that point in time when the depositions were taken. And furthermore, each deponent, the questions that were elicited, the testimony that was taken has certain issues, particularly with Mr. Wolf, Gary Wolf. He is not a lawyer. He was asked regarding an opinion of title as to the chain of title. We submit that that is the unauthorized practice of law.
All right, let's go back, though, because
Okay.
I'm still a little confused here. You say the trial court took judicial notice of the initial deed that gave Tipton an interest in the property.
The trial court was never asked to give judicial notice.
Did the
of the
trial
deeds.
court take judicial notice? I mean, I thought you said the trial court took judicial notice of the deed.
No, Your Honor. The trial court took the depositions and said he would consider them. The deeds are exhibits to the depositions. They were not individually admitted as exhibits to the hearing.
All right, so the deed was attached to the deposition that the trial court said he was going to read.
Yes, Your Honor.
And does the deed show proof that Tipton had an interest in the property?
The deed does show that.
Was there any proof presented showing that Tipton's interest ever went away?
We would submit that the receiver's report reflects that he was not listed as a interest holder in the property, as well as the testimony from Mr. Wolfenbarger stating that he believed that Tipton did not have an interest in ownership.
Was there anything, I mean, any deed?
There was no other deed.
Anything showing that other than opinions stated by people that for some reason he no longer had an interest?
There was no other deed presented to the trial court.
Thank you.
But concerning these deposition testimonies, again, Mr. Wolf, who is not a lawyer, was permitted to offer an opinion of title. He was also not asked to testify at trial. He is not a lawyer who is exempt from subpoena at trial. His deposition was not read into the record. Our objections were not noted on the record. Our objections were not read in. We were not allowed to address those at the trial, and the same goes for Mr. McCoyne. Our issue with Mr. McCoyne's deposition specifically is that it violates Rule 704 of the Tennessee Rules of Evidence, and that he offered legal conclusions as to an ultimate fact proven. That's the job of the trial court, to determine legal conclusions, not the job of a deponent or a lawyer. Specifically, I think that Mr. Wolf's deposition in particular is of note because, again, he is not a lawyer and offered these opinions, and ergo, it's not competent proof. As to Mr. McCoyne's deposition, counsel was unable to note its objections on the record at the trial court level. We did not receive an evidentiary ruling concerning our objections. The purpose of deposition objections is for the trial court to rule on those at a later date, if needed, if the deposition is read into the record. And we would submit that the receiver's report and the testimony from Mr. Wolfenbarger is the competent proof at trial, because a party without standing elicited this remaining proof that was presented to the trial court. And as such, the Worley appellant's proof is that which should be reviewed by the trial court, rather than the lack of proof from Mr. Tipton or the incompetent proof from Hydrosports. I think I'm out of time, so thank you.
You have your time for rebuttal. Thank you. Hear from the appellee.
May it please the court, my name is Tyler Weiss and I represent the appellee Darrell Tipton. On November 4th, 1988, Darrell Tipton, along with Michael Ross, Dale Ross, received a 1/3 each undivided interest in 260 Industrial Park Drive, Madisonville, Tennessee. It is unrefuted that Mr. Tipton's interest in that piece of property has never been conveyed, or he has maintained that interest since that initial time. He's the one who's filed the lawsuit. In summary, and I don't want to go hit the facts as well, unless the court wants to hear from myself, but I will try to just kind of hit some high points and highlights here. First, let me talk about the waiver issue. Mr. Tipton, I'll first start out stating that if you see the court order that set the matter for a evidentiary hearing, specifically states that the matter was set to determine the defendant's interest in the piece of property. And Mr. as pointed out by counsel, Mr. Tipton is a plaintiff in this matter. So the hearing was specifically set for the Worleys, for Wolfenbarger, and for several other of the matters. And it specifically set that out. After the court heard the testimony, and the only testimony that was presented was some brief testimony by Mr. Wolfenbarger and two documents that was submitted by the Worleys. That was the only thing that the court did hear. From that matter, the judge took the deposition transcripts from both Mr. McCoyne, or Attorney McCoyne, and Mr. Wolf, and sent out an email, as you see it in the record, where it states specifically the findings of the court up to that point, setting for a subsequent hearing concerning Darrell Tipton's interest on that matter, which I'll point to the court. No one else submitted any additional proof in that matter. Mr. Tipton's interest, the trial court was correct in determining that Mr. Tipton had an interest because he's maintained that interest, and he's always kept that interest. The fact that he didn't show up to a hearing concerning the defendant's interest in the matter, as I stated in my brief, is somewhat confusing and interesting, I guess, to say the least. The fact that Mr. and I'll point to the court that the fact that Mr. Tipton didn't show up, there was no finding by the trial court that says that he didn't show up at the hearing, and that there was no motion made by the Worleys to ask the court to make a finding that Mr. Tipton have somehow waived his interest. The fact that he didn't show up to a hearing concerning the defendant's interest does not waive that interest that he has in that piece of property, that 1/3 interest in the property. The trial court was correct in finding that at the end, at the filing of the petition action, that Mr. Tipton, Mr. Wolfenbarger, and Mr. Ross's interest, respectively, was 4/12, 6/12, and 2/12. That each of them receives the money in proportion to their interest to the property. It's interesting to me that the Worleys even care what interest, I guess, with the Rosses, as the trial court found. But nevertheless, the court was accurate and correct in finding that Darrell Tipton has an interest. And the argument that they say that there was no competent proof, there was competent proof. There's competent proof by the there was competent proof by Attorney McCoy, and there was competent proof by Mr. McCoy. I'll point to the fact that Hydra Sports took those depositions as if no matter. There was an order put down by the court. There was a motion filed by Hydra Sports Court asking the court to take those depositions for proof. There was no objection that was ever raised or made by the Worleys or anyone else for that matter. There was an order put down by the trial court stating that Hydra Sports is the one who's to take those depositions. There was no objection to that order. There was no response filed by any party at all. The fact of the matter, too, is Hydra Sports took those depositions pursuant to court order, pursuant to everyone's apparent agreement and understanding that they were going to take that. During the depositions, there was never an objection made as to Hydra Sports taking those depositions, or that the fact that those depositions were going to be taken for proof. The Worleys had made several objections throughout those, I will agree, but it never went to the fact of who's taking the deposition and whether those depositions are going to be submitted for proof. The depositions were taken, the transcripts were submitted to the trial court. Never an objection to the depositions being submitted to the trial court. They were filed with the court. They were submitted to the court. And I will point out that there was a certificate by the clerk of the court certifying those depositions pursuant to Rule 24. Those depositions were properly before you. They were properly taken by a party in the matter that was ordered by the court, that everybody agreed upon, or never raised an issue about it until now, about the fact that those matters were taken. And I'll point out that in those depositions, he's correct that the deeds, even the interest of the Worleys, was submitted through Attorney Wolf's deposition. But I'll state, if you read the arguments of the Worleys throughout after the hearing concerning the defendant's interest, they were arguing about the deeds, about the initial deeds. So even throughout their whole argument they are acknowledging and in essence admitting those deeds, because they're arguing. Their whole closing argument is concerning the 4 deeds. And I was stating, trying to kind of hidden some of these points here about again, you got the 4 initial deeds. Let me point out to it, they're talking about this receiver's report. First, as I point out, the receiver's report, it is not a conveyance. It is not a court order. It's not a finding by a court. It is, as Your Honor pointed out, is a mere opinion. It is an opinion of another individual, which, interestingly enough, if you read that receiver's report, it appears to be based upon perhaps the second deed. I'm speculating at this point in time because I don't know. But interestingly enough, the Worleys are attacking that second deed. And I'll state the second deed is the one that Mike Ross deeded or transferred his and his brother's half interest to Mr. Wolfenbarger. They are attacking that deed and saying that Mike Ross was an attorney unauthorized to practice of law, and that deed's a nullity. So even what they claim as the proof presented at the hearing at the defendant's to determine the defendant's interest in that matter is based upon a deed that they're saying is an invalid deed. But nevertheless, what that has to do with Darrell Tipton, absolutely nothing, because his interest was secured from that initial deed that was entered back in 1988 and was maintained throughout that. The conveyances and the off conveyances and all the matters, all the stuff that was going on was taking place by Mike Ross. And I'll point to the court, which is interesting to me, that the information or the opinions that they're basing at least some of this information on is from an individual who was sued for and found in violation of the RICO statute, the Racketeering and Corrupt Organizations Practices, along with several fraudulent misrepresentations. Namely, that was the basis of the judgment, Lee, that was that the Worleys are standing on, or where they derive their interest in this matter, is from a fraudulent misrepresentation by Mike Ross, and the testimony that they are using to find the opinion, I'll say the opinion testimony, is a hearsay statement from Mr. Wolfenbarger based upon an individual who has several judgments against him based upon fraudulent misrepresentation. The court, speaking on the court was correct in its admissions, as I said earlier, admissions on the deposition testimony of both of those individuals. The courts found that the individuals were highly qualified in their respective fields. Attorney McCoyne, I don't want to. He's been practicing law for over 40 years, I think, or somewhere around over 30 years. He had been practicing law. He had been doing title opinions and rendering title opinions and doing title searches. As far as Mr. Wolf goes, Mr. Wolf was a long-standing title abstractor. The Worleys even admitted in the deposition that Mr. Wolf was he was a qualified in making sure what deeds are there and things of that nature, and finding out the chains of title. So they never once take issue with any of their qualifications, the reliability of the testimony of Wolf and McCoyne, the facts that they use, or the methodology. What they're taking an issue about, one is whether the depositions were, I guess, submitted properly, which I would say that they've waived that argument, A, but B, it was submitted properly nevertheless. And secondly, the issue they're taking with is the ultimate, what's be considered the fact. The ultimate issue here is who has title to the property. The trial court was correct in its conclusion in that matter, finding that Darrell Tipton has that 4/12 interest, Mr. Wolfenbarger having his 6/12, and Mr. Ross having his 2/12 interest in that matter, based upon those highly qualified individuals' testimony and the exhibits there too. I'd ask this court to uphold the trial court's order. It's unrefuted, as I stated, that Mr. Darrell Tipton has his 1/3 interest, and is based upon competent and highly qualified testimony of both Gary Wolf and George McCoyne. And I'd point that even the deeds are admitted, or have admitted by the Worleys as far as the chain of title and Mr. Tipton's initial interest. If you have no further questions.
I hear none. Thank you. Here, the appellant rebuttal.
Concerning, I think first, the deposition testimony again, the appellee is stating that this is competent proof in front of the court. Again, to reiterate, a party without interest noticed these depositions and took these depositions. At the depositions, statements, quasi-objections were made concerning Hydrosport's standing to take these depositions. Hydrosports had no interest in the sales proceeds, yet Hydrosports was taking proof as to the same. We submit that a party without standing cannot continue in the litigation. I would kind of equate this to a personal injury action. If an insurance company is paying MedPay into court, and then the court is and then leaves, yet shows up to the trial later and attempts to argue damages, that would be improper. It's just like it was improper here for Hydrosports to involve itself in the litigation regarding the sales proceeds. As such, this proof is incompetent. Hydrosports was the improper party to take this proof, and yet the court accepted it, and that was error. Concerning the evidentiary hearing, the court certified that as a final hearing at the evidentiary hearing, and concerning Mr. Tipton's interest. As he filed this lawsuit, it was his burden to demonstrate an interest in the property as well as an interest in the sales proceeds. Mr. Tipton failed to do that. He did not show up. Regardless of the fact that this concerned the ownership interests of the defendants, whether or not the order says that, the Worley's motion did not request that. The Worley's motion requested that the distribution of sales proceeds be allocated, simply. And ergo, Mr. Tipton should have been involved in that hearing. Concerning the additional objections as to the depositions, while no objection was made to Hydrosport's filing requesting that the depositions be made part of the record, the Worleys did submit a motion in limine prior to the trial as to the depositions, and then submitted the issues, the evidentiary issues concerning the depositions and the testimony taken as to the improper proof, the fact that Mr. Wolf was not an attorney and was issuing a title opinion, and the fact that Mr. McCoy was issuing a legal conclusion on an ultimate fact. Again, Hydrosports did not have standing to take these depositions. And again, we would refer the court to the receiver's report that was the competent proof before the court that day. Hydrosports did not have standing to submit the depositions to the trial court. The counsel for the Worley appellants made that note to the trial court, and the trial court agreed with counsel that Hydrosports did not have standing to continue on in that hearing, yet the trial court accepted that proof. And the appellee cannot now rely on the improper evidence merely because it was submitted to the trial court. That was, again, improper, and Mr. Tipton should have been there to defend his interests. We would further submit that the trial court was willing to accept an agreement between Mr. Wolfenbarger and the Worleys. If you'll review the record from the evidentiary hearing, there were several recesses taken in which Mr. Wolfenbarger and the Worleys attempted to come to an agreement as to their percentage interest, and regarding a 75% interest for Mr. Wolfenbarger and a 25% interest for the Worleys. The trial court was willing to accept that day, and that did not involve Mr. Tipton. And we submit that that was the entirety of the $850,000, and the trial court was willing to accept that settlement. So that's all I have. Thank you.
Of course, thanks to counsel for both sides. We appreciate your arguments this morning.